the judgment in my favor of the Rajasthan division bench is that the RERC has no jurisdiction. They are in appeal. They are entitled to argue their appeal. Now, kindly see page 9. Pursuant to your request, Mala, may I read it? And the annexures show the entire data from my inception to the present day. There are several pages of annexures. He wants my account books, my commercial confidential information, every single invoice.
Every aspect that you mentioned in these tabulated statements,
It's a chart.
it can't be accepted as your
It's a chart.
report.
Yeah, the
Can't be
documents.
accepted.
It's a chart.
There must be supporting documents for that. Your record has to be
Every
examined.
invoice has to be produced.
Of course, if it's a sum.
If you do not comply with the order that we have passed, we'll have to draw an adverse inference against you. That we will make clear. If you choose to abide by the order, abide by it. Otherwise,
Your
we
lordship.
can't hold a gun to your head, but we'll have to draw an adverse inference.
Your lordship may hear me for 5 minutes. What did your lordship want me to produce? Did your lordship, I ask myself, I ask your lordship respectfully, did your lordship's intend that I should produce every invoice, every
Records and data mean originals.
produce?
These are not originals. You just make a tabulated
This is a
statement.
chartered accountant certificate.
These are not originals. Your records,
Hundreds of registers.
That is for the RERC to break its head over. You can't say that I can't carry hundreds of books.
Absolutely sure. Your lordships did not
The
intend.
order
I
dated
should produce
4/4/2025 passed by this round makes it clear that respondent number 1, who was represented by a learned senior counsel on that date, undertook
Well, your lordship may specify.
produce the witness along with the records and data before the Rajasthan Electricity Regulatory Commission on the stipulated date, that is 6/5/2025. Order dated 14/8/2025, passed by the Rajasthan Electricity Regulatory Commission, is placed before us, which demonstrates in unequivocal terms that respondent number 1 has not been abiding by the aforestated direction of this court. In the event respondent number 1 fails to produce the original records and data that it wishes to place before the
That has been summoned.
which have been summoned.
Nothing.
The original records and data which have been summoned by the
Well, your lordship
Rajasthan
may
Electricity Regulatory Commission. What is
But he wants every
Indeed.
invoice, every voucher. It'll be truckloads for the last 15
One
years.
moment, Mr. Chidambaram. Fails to
produce original records and data.
as was
Which have been
summoned by
summoned by
as was summoned by the Rajasthan Electricity Regulatory
Where is
Commission
the summons?
along with the witness
Where is the summons?
on, when is the next date fixed?
It has not fixed because this person we wanted to.
They've taken an exam.
Any
The
date?
lordship may fix the date.
Kindly specify
on-
what records I should.
The records that they have asked for, you produce them.
Well, he wants every voucher, every.
Whatever they wish. You can't say that I will not cooperate while we are still of the matter.
Last 15 years, please see my
8th
difficulty.
September,
Grateful.
on 8th September,
And you're wrong.
the Rajasthan Electricity
No,
Regulatory.
8th September, it's
And-
simply not possible. to
Very good.
produce
15th September.
Vouchers and. receipts.
15th September,
Well,
15th September, Mr. Chidambaram.
Yeah, very well. Well, that's a non-miscellaneous date.
Please hear me.
No, this is on the, before the RERC.
Okay, so 15th September. And your
15th
lordship may
September,
place-
we'll take it up on this
Please
matter
hear me
for
2
hearing
minutes.
on
My lord.
7th
may-
October.
My lord may kindly hear me for 2 minutes.
We have already heard you, Mr.
Very
Chidambaram.
good.
Your client, on the face of it, is blowing hot and cold.
Please allow me.
We've already told you when the senior counsel who represented your client heard this order, he had no objection. Now, second thoughts on the part of your client, with a second counsel now, and a new stand is sought to be taken. That is not happening.
Please allow me.
That is not happening.
Please allow me 2 minutes.
We will hear you on 7th October. In the meanwhile, you produce the records.
Please allow me on this order
On the
What-
next date, we will hear you. You can't play around with the orders passed by
What your
this.
lordships
Sorry.
intend to that I should produce a record,
Produce whatever it is.
ledgers.
Engage a trolley, a van,
But
a lorry, whatever is necessary, carry all the records
every
and
voucher, every
place it
bill,
before them.
number one.
RERC is not someone whom you need to distrust, is it not? It's
No,
an
no, no.
authority.
RERC says he will share it with everybody. My commercial.
Where did you get it from that the RERC wants to
RERC
put it in the
hearing
public domain?
says everybody will be.
Are you planning to advertise it? Where is that?
That is what they.
Did the RERC say that whatever,
Can I just explain?
if it may refer to it in the order,
Yeah. this-
it will only refer to it in the order, and we've already passed, stayed the passing of the
Absolutely,
final
Lord.
order.
Yeah,
Where is the question?
yeah, exactly. Lordship, please.
No,
Next matter, Mr. Chidambaram, we have heard you.
no, I'll just tell you.
The only thing that the RERC can do is refer to it in its order, which we have already
That's what it
stated.
says. Please allow me to read the sentence. Registry is directed to provide the copy of the information submitted by Southwest to the respondents, stakeholders, and the petitioners also. Who is stakeholder? Everybody before the.
Which
RERC
information?
given.
That's some other information. Record is to be given to the RERC. You are reading something
This
else.
is the order, Milord. This is the order. Please see item 3. Registers directed to provide the copy of the information.
The order dated, mention this, the order dated 21/4/2023, passed by the RERC with regard to disclosure of details, would not cover the original records which would be produced by R1 before it.
Please add the original records.
Original records would be seen by them. That is,
Yes,
these tables which you have filed, these tabulated statements would perhaps be shared with them. That's-
No. Your lordship may make it clear.
Yes, we've already said that the records are not to be shared. Where is the question? If you take a lorry load of records, the
There will be
RERC
several lorry.
hardly make copies and distribute it to
Several
everyone.
lorry roads. I'll have to make copies and give it to the registry.
We've already said that the records are not to be shared with the parents.
No, practical difficulty. So 15 years records. Can
You already said engage a couple of lorries if it's necessary. Take it.
No, please give us more time. Please, government, give us more
You
time.
don't have to sift through your records to select.
I have-
All your records you will take.
I have to-
They will break their head over it. Why are you concerned?
Please understand a mining company.
You obviously want to sift and select your records.
I don't want to select.
For that, you need time.
It's a bit
If
tabulated.
you don't need,
Vouchers.
you don't need to tabulate it. We are asking you to produce the records. Where is the question of tabulating it?
He asked me for a particular bill or a particular.
Then you search for it in the court. That's all. There's no question of your,
How the RERC works, Milord.
we have not said anything. You produce the records, that is all.
That is
That is
not
all,
how the
Mr.
RERC works.
Next
We are
matter,
here before the
next
RERC.
matter, Mr. Chidambaram, I've heard you long.
Here before the RERC, he is brusque, he is abrupt, and they.
We don't know about all that. You take it up with the authorities if you have an issue with who has been appointed. there.
No, your lordship may at
Sorry.
least make it clear that the records will be kept only for the perusal.
That we've already said, it will not be shared. That's all. There is,
Not
there ends the
shared with
matter.
the stakeholders.
There ends the matter, Mr. Chidambaram. We've heard you long enough.
Please,
Sorry.
please repeat that,
We've said it, that the records to be, the order dated, whatever that date was.
21st April 2023.
say item.
April 23 will not extend and cover the records to be produced by our law. Next matter.
This is 6th of May, Milord. This order is 6th of May. Your lordship may mention that.
6th of May. There's no order of 6th of May.
There is an order at page 34.
IA 17477.
IA 174.
6th of May of? 6 of
Your lordship.
2024.
No. IA 174750. There is a order of, at page 34, which
Your lordships, just on this particular point, 6th of May order is not talking about the records post that. It talks about the record which was already been submitted on 6th of May. And that is a chart and the submission which was already given to us. Your lordships,
Nothing more, Mr.
Milord, this order
Nothing more.
65, item 3 says.
Nothing more, Mr. Chidambaram.
Your lordship
Next
may
matter.
mention this order also.
He's already said that that information has been given to them. What remains then?
No, it will be shared with the.
It is already shared.
He said
No,
already.
no, it's not being
They have
shared.
filed it in the Supreme Court, your Lordship.
Shared.
Same thing.
It's not being shared.
Sorry. That is a tabulated statement. It's not part of your
The
record. anymore.
tabulated statement can be shared.
Item 52, please.
My lords, an opinion
You
on
filed
behalf of
a
petitioner.
letter, bereavement in the family.
Yes, my lords. The council.
Learned counsel
passes-
for the respondent filed a letter seeking adjournment on the ground of
Petitioner,
bereavement in the family.
petitioner.
You said in the letter, advocate for the respondent.
The apology.
Is it the respondent or the petitioner?
Petitioner, my lords.
Why are you killing off someone in the respondent's advocate's family then?
Apologies.
Petitioner,
My lords, interim order by
earlier interim order shall continue
much obliged.
to operate on the next date of hearing. Services to be completed perhaps?
It's not even my.
Final reply.
Only one respondent?
That's one number 5, we have received the
No,
comment.
but the others are also served?
Yes, my lords, we have.
Office report states my lord in service.
Services complete?
Yes,
Very
my
good.
lords. Much obliged.
My lordship, we are seeking 2 weeks' time to file, to bring on record the legal.
LR of R1.
Of respondent
Right.
one.
Learned counsel for the petitioners, take some more time.
Lordship,
You take
just want-
necessary steps in relation to deceased respondent number one. You filed a counter.
I have already filed, the LRs were already on record before the Honorable High Court. They already need to file the amended memo party that was filed in the High Court.
They already
They are-
parties
already-
before us.
No, my lordship, they were in before the High Court, my
Why
lordship.
you failed to implement?
Yes, we failed.
They were parties to the impugned order.
They were parties to
Yes.
the order, yes,
Then
my-
you went by the earlier cost title.
yes,
and
my lordship, there was a mistake, the synopsis was not correct, we'll just correct the synopsis.
Lordship, I have placed the order.
Take necessary
given
steps.
it-
Yes.
You won't say LR petition, take necessary steps in relation to deceased respondent number one. Yes,
Grateful, my lordship.
Date is
list on 28th of.
28. Obliged.
Item 54.
My lord, this is a suit, this was a suit for, my lord, injunction.
What happened to the mediation before
My
the
lord, the
March
mediation failed, my lord.
mediation?
Mediation failed, my lord. My lord, the issue in this case is that this is a suit for infringement of a.
Because I had to file a counter affidavit, which we have filed.
Three main points in this case, my lord. First, my lord, this is a suit
We
for
have
injunction.
filed the counter affidavit this morning itself.
Oh.
The lordships can have it on board next week. If they don't want to file a rejoinder, have it next week. You know,
My lord, I'm in some difficulty next week. Would your lordship take it up in the, my lord, would your lordship consider taking it up on a Tuesday?
On a non-miscellaneous.
Tuesday, my lord, 16th.
The difficulty is we have one non-miscellaneous day per week.
My lord, I will,
Makes it very, very
my
difficult.
lord, I will
because-
finish in 15 minutes by the watch.
So even if we do give you a date, Mr. Bachchandra, then the matter goes to the bottom of the list. Which
I
means
understand.
that your matter may not in all probability reach on that day.
Whatever is,
You will
whatever
form
is,
part of the queue
I'm sorry,
and slowly climb the ladder.
I understand. My
So
lord,
that you'll have to wait for your turn once you join the queue.
whatever is convenient, my lord, whatever is convenient.
Then counsel for the respondents. All the respondents?
yes.
States that the counter affidavit was filed today morning. Registry shall verify and place the same on record. Rejoinder thereto, if any,
No return.
may be filed, if any, may be filed by the next date of hearing. List on 14th October.
Item 55.
55 readings are complete.
Fine. Public Service Commission believes in being on a different page when compared to the Kerala government.
There was only one point here.
This is the second time that I'm coming.
But
in.
it's
I
actually.
already made costly comments against you in
Just
the earlier round.
just one point I'm saying. The only ground we took was that daring subject is not studied right. We did not have this
The
daring.
university says it's equivalent. The government says it's
Then not
equivalent.
right because.
Then where is the question of you undertake recruitments for the government?
Fair.
And the government says we recognize this
I
to be
see
an
the, I see the
equivalent.
point. Only one, he was ranked, he should my lord feel like that. He was deleted from that rank list. So he'll just take his place or whatever, as per his
So
marks.
we'll dismiss this SLP. Whatever follows will follow.
Yes, that's.
But you need to put your house in order, Mr. Nair.
I will try.
You
That-
go by the advice of the
We
government.
made enough comments in that earlier
I know.
judgment. I was sitting with Justice Narasimha.
Yes, I know.
Then
I
what have
made
you,
it.
you've not
No, this is an older
taken a
case.
leaf out of
It's an
that.
older case.
This is an older case.
Yes.
We find no ground made out to interfere with the impugned judgment passed by the Kerala High Court, especially if it's
Right.
dismissed.
Article 56.
56 letters there. Then counsel for the respondent seeks some time to file a counter affidavit. It will, and that regard will be done within 4 weeks. You will, it has to come, wait till the order is pronounced at least. Shall be, needful in that regard shall be done within 3 weeks. Rejoined at date if any may be filed within 2 weeks thereafter. List on 4th November. Interim order dated 18/7/2025 shall continue to operate till the next date of trial.
Article 57.
Please, Lords. Because your lordships were indulgent enough to give me an interim order. Despite that, what the state government is doing is, can be seen from my IA, this may see annexure P48.
IA.
Which IA number?
Plus IA number one
Hearing for this stage in this matter, my lord.
198420, Lords.
198420.
Yes, Lords.
Which annexure?
Plus annexure P47, Lords.
Page.
Page 6 of that application. So, absolutely for a different context, I say that please give me extra time for implementation of the project, and I'm sending you the draft as per your scheme. I'm making those payments. In response, Lords, on next page, citing your lordship's order, may I just draw lordship's attention to the next page?
Yes.
Well, as the government writes to me and says, regarding the above subject, it is stated that SLP number so and so, the Honorable Supreme Court has passed the following order. Till the next date of hearing, status quo obtaining as on this date shall be maintained with regard to the properties of the petitioner. In view of the aforementioned order,
What about service? Someone is appearing.
My lords, I am appearing for this state.
Yes.
My
and
lords, I have
yours
received
hence
this copy
Honorable
only
Court
on
has not
Saturday.
granted any stay on the demand notice.
Council.
My lords, firstly, this application has not been served on me and I've entered appearance only on Saturday. I'm requesting if I can put in a reply, my lords.
Put
I
in
need
a
to seek
reply,
instructions in this matter.
But this kind of attitude on the part of your authorities on the last date.
My
itself
lords, I
is
don't
very
even
bad.
have the application, my lords. I understand what's
Leave
calling
your-
from my
leave
lords.
your application.
Please, my
That
lords.
Page, earlier we looked at one page, is not, what page was that? 237.
Please, my lords.
Have you got the SLP papers, madam?
Our committee's reports.
Yes. 237. You already suffered an adverse order and then you say.
Have this next week, my lords, because I don't
We
have
will
the
take
papers
further
with me.
necessary action in this matter in the light of the earlier decision of the Supreme Court, as if the Supreme Court gave you liberty to reopen the issue. That was never there. We in fact asked the council to
matter
produce
next
the
week,
order.
my lords,
After
I'm
that,
only
he said there's
requesting-
no such order which gave liberty to you to reopen the issue. And then you suddenly come up with this fresh demand, obviously for reasons that we cannot acknowledge in open court.
My lords, I'm only requesting if my lords can have this next week.
We will
allow me
have
to
it
take
next week,
instructions.
but please examine this matter.
Very well, my
This
lords,
kind
I'll
of
do.
attitude, we will not take too kindly.
Very well, my lords, I'll
The
do.
council appearing for the state of Punjab seeks some time to file a reply. Notice they're again saying that they'll take some coercive action.
Because they are saying that, as far as my implementation of project is concerned,
Sir, you held it up.
they said we will not allow that because you have not paid as per the demand notice. Saying that there is no stay of the demand.
Next Monday, we'll take it up. In the meanwhile, you find out in latest.
Very well, my lords.
Grateful to us.
The learned council appearing for the state of Punjab seeks some time to.
Because my friend will file a reply to my IE.
Special leave petition as well as.
Don't have the IA, my learned friend can serve it to me, I'll file a reply.
2025, a copy of the said IA shall be supplied to the
File
learned
it.
council for the state during the course of the day.
You
Please
file
not.
IAS without serving a copy.
It was not by instruction.
If she filed, entered appearance only in the morning,
My lords,
But-
I've entered appearance on Saturday, but the
On Saturday.
IA has not
The
been served
department
along with the
will-
papers.
Sometimes takes time because we have
well,
served
we'll
also.
just serve her
Yes,
another copy.
immediately. Grateful.
Obliged, my lords.
Next Monday. session.
May it please, my lord.
58. Yes.
May it please, my lords. Lordships, in this matter, by the judgment
Home
which was
Secretary was
uploaded,
required to-
yes, lordships, on 31st July, lordships had granted 8 weeks' time, lordships. So lordships may see, if lordships, it may be listed in the last week of September.
It
Lordships
was
are
to be
directed,
submitted by August 25. Is it not?
no, lordships, the judgment is of 31st July, lordships. The judgment was uploaded on 31st July. Lordships, para 37, lordships have granted 8 weeks' time. Lordships
good.
may list it after that.
Because I
For
want to place
compliance with the judgment dated 14/7/2025 in terms of a report being filed by the Principal Home Secretary.
Lordships.
List on,
my lords, I want to place certain additional documents. You want to keep liberty to file.
list on 6th October. Then counsel for the petitioner is also at liberty to file additional documents. Why additional documents at this stage?
There's a
Everything
call
is
history
over.
which I have extracted.
Sorry,
Call history which I have extracted.
what have you extracted?
Call history, Your Lordship.
Call history.
Yes. When I communicated to the
Very
SHO, the order. I have correspondent number 1 in this.
They can serve as a copy, lordships. We will file it along with
When
that.
counsel for the petitioner is at liberty to file additional documents, if any, with advance copies thereof to the land council for the state
Grateful, lordships.
I am grateful.
public contemners.
59.
In 59, there are multiple orders of Delhi High Court.
Yes, in
Because in 59, I will mark the matter by legal aid. I mark the matter by legal aid.
Why legal aid?
I received a letter from legal aid.
We did not ask the legal aid to,
Received a letter from. legal
issue
aid.
was notice.
Yes.
Notice was issued and status is not even, there's no indication as to whether she's been served also.
No, there is an official letter. or-
Served, is it? 22nd August is the last law. You have a later or what?
The office report saying 26th August.
I have a 22nd August or
Today is 25th.
22nd August, OR says nothing about service.
24th.
But you've been engaged by the legal aid.
I received a letter from the legal aid to ask.
This matter.
Yes, ma'am. I filed my power in the morning. I request some time to file a counter.
Wait.
You got in touch with this respond number one?
Yes, she's online.
Have you complied with the orders of?
Yes, Mulas, yes. The office-
Deposited the amount?
Because everything was done, office report is also there, not
No,
suggesting that
official report doesn't disclose.
she has been served.
No. Have you deposited the rent as ordered on 22/8/2022? Earlier it was said 100%. On 22/8/2022, it was modified and said.
That's for the respondent, not the petitioner.
Oh,
She has to. He's the land, she's the
Yes.
land.
I need it in instruction.
But
Because I
what
filed my
is
power
this?
today in the morning. I
At
would-
every drop of the hat, you have ensured that the
Perhaps
orders of the
perhaps
court.
the lady approached the legal aid.
Yes, that is why they have
Legal
sent a letter
services
to me
committee.
saying that you are to be.
But we'll give you a short date. This is a clear case of abuse of process, nothing short of it.
2 weeks, my lord.
No 2 weeks, 1 week.
Fair enough.
Learned counsel appearing on behalf of respondent number 1. There's only one respondent. On behalf of the respondent, states that he was instructed to appear only to the morning by the Leading Services Committee and seeks time to file a reply. Needful shall be done within 3 days. Adjourned data, if any, may be filed within 2 days thereafter. List on next Monday's.
But may I make a short request? Can it be on next Friday or Monday? There is some religious.
Monday, please.
I'm in a personal difficulty on Monday, so I'm already requesting for Friday, next Friday.
Ask your colleague to appear, sir. You have a very bad case.
I understand, but on Monday I have a personal difficulty.
Ask one of your colleagues.
Because the difficulty is since legal aid has migrated to me, I'll have to be
Your office colleague. He can represent.
Fourth.
My lords, obliged.
First, commission has filed counter, my lord, in page 5. They have admitted my case actually, that yes, I am only see page.
Is this you're appearing for whom?
I am appearing for the School Service Commission.
Is this the only writ petition which was filed before the judgment? Are there others who have questioned
No, others have not.
the fact that they've been included in the tainted list?
No, they have not yet filed it.
This lady filed a writ petition prior to the passing of the judgment itself.
Yes.
Are there others who have also done that? Does any of you know, Mr. Vivedi?
No.
Did anybody else file a similar writ petition questioning their inclusion in the tainted list?
Some petitions have been filed, but
Those petitions will have to be dealt with on merits. We have not gone into the issue of whether the tainting itself is valid or not. If someone has raised the issue that my name ought not to have been included in the tainted list, these are the reasons for that. The High Court has to adjudicate upon that. So the High Court can't say that because the division bench held cancelled the selection and the Supreme Court affirmed it, this writ petition becomes infructuous. That doesn't follow.
in this matter, High Court didn't say that. Original matter.
The High Court refuses to entertain the writ petition on that ground.
That's right.
That won't follow. The High Court has to adjudicate this writ petition.
Who doesn't?
Who is R4? R4 is the CBI.
Yes.
CBI is not an STP.
Not the
Yes. So we'll dispose of this then. Direct the High Court to adjudicate the matter.
The exam is there, my lord. There is very.
We can't step into the shoes of the High Court and decide the
High
writ
Court
petition.
release the matter, my lord, only. And when there is
You
admitted
press
case,
for interim relief then.
they have admitted in the counter.
No, by virtue of today's order, you go and press the matter before the. That's why.
Very well, my lord.
The perusal of the leave granted, perusal of the interim impugned order reflects that the High Court was of the opinion that the writ petition filed by the petitioner, by the appellant, did not warrant consideration on merits owing to the judgment of this court in Civil Appeal number 4805 of 2025 and batch titled State of West Bengal. And batch don't say this. Civil Appeal number 4805 of 2025 titled State of West Bengal versus Baisakhi Bhattacharya within brackets Chatterjee and others and batch. Full stop. However, we find that the writ petition in question was filed long before the adjudication of the matter by the division bench of the High Court, which came to be confirmed by this court in the aforestated civil appeals. Full stop. The grievance of the petitioner as to whether or not she was liable to be treated as a tainted candidate was never adjudicated by this court, by the division bench or by this court. The said issue therefore remains open for adjudication in the writ petition filed by her, which is still pending before the High Court. We accordingly dispose of the writ petition, permitting the petitioner to pursue her writ petition before the High Court. It is also left open to her to seek appropriate interim relief therein as deemed appropriate. Don't say as deemed appropriate. Therein. the appeal is accordingly allowed in the frustrated terms.
7th is the exam, 7th of December.
You need to approach the High Court, file an IA, seek whether the interim relief.
I'm obliged.
Item 61. Yeah, please.
Yes.
So we have entered appearance in the matter, but file a short counter. Should we kindly attend with comments?
Correspondence already filed.
Here, you filed the letter and described yourself as advocate for the petition.
Oh.
Learned counsel for the respondent. Seek some time to file a counter affidavit. Needful in that regard shall be done within 3 weeks.
Anything
And
can happen.
finder thereto, if any, may be filed within 1 week. List on 14th October.
Much obliged.
Item 62.
Yes. Doctor's appointment. Can't you at least adjust your doctor's appointment to suit?
I apologize.
And especially after you secure an interim order.
My lord,
You secure an interim order, then you get a doctor's appointment on the date that the matter is coming up. You are appearing for the response.
correspondent number 1. Well, I am every procedure according to this one order, my lord. Kindly
Sorry?
send this honorable court order.
What happened?
And
What is this order?
Service is also not complete.
Service is not.
kindly come to the page number 12, my lord.
Well,
12. The
Yes.
first where in reference of the order of this court, 29th September 2009, by this court directed that henceforth no unauthorized construction shall be carried out or permitted in the name of the temple, church, masjid or gurdwara, etc. on public street, public park or other places. But again come to the page number 13. 13, the second para in the bottom middle.
yes.
To ensure the implementation of direction issued by this court, counsels who have been arrived at the bar, and in our opinion, rightly, that the implementation of the order should be supervised by the concerned High Court. We constantly remit the above matter to the respective High Court for ensuring implementation of the order in this effective manner.
Well, the High Court has followed it. Now we are not
Yes,
following it. We'll give you a short date next Monday, please. And counsel for the petitioner filed a letter seeking an adjournment. List on. Give next Monday's date.
Yes. Great.
Request. Dismiss the matter. Okay. After the 50 days. Three.
Because as for office report, I
I'm
was
for the respondent, I'm filing wakalat today, not, I just need a short date, I'll file a counter.
Very good.
Lordships had put it for hearing on 13 May, so it couldn't come up. So Lordship may just indicate some date to the
We'll give you a date on a Wednesday.
Wednesday, yes, please. That's all I
It
would.
was supposed to come up with
Yes.
the week commencing 13th.
Yes, but because of the
10th
change.
September.
It's
List for hearing on 10th September, pleadings to be completed in the meanwhile.
grateful.
Obliged.
Obliged.
Item 64.
Item 64, note one humble request on behalf of the state law. What is the difficulty note? They have filed the resignation ROC certificate that we have verified law. But as regard the sister companies are concerned, he was the director at the relevant time law. What we have done, Lord, we have filed a certain transactions note from the account into the sister companies and in his own account note. And I have asked the department to send certain account statement we have received, or we have filed, but the relevant period for which the petitioner was the director in sister companies awaited, Lord. I may be accommodated for
So
a.
he was no longer a company in this bike
In
board,
his company,
In
he
bike board,
he
he's
is
not there.
He is resigned, Lord.
but he was there in the sister company which received money from bike board
Please, Lord.
and then he transferred it into his own account.
And even from the sister companies to his own accounts, Lord. This is the CD 186, 183 and 186 disclosed as such, but I am seeking my Lord's permission to file those documents showing that yes, there was a transaction from the sister company to the main company and to
We'll take it
the.
up next Monday, Mr.
Sir, I have no difficulty except that my learned friend's statement is wrong for two reasons. The bank statements are already here. My learned friend may just show your lordship that he has, in fact, I don't know why he's making this statement because he filed these documents on 19th of August. They're already before your lordship. And none of those, and I must say this,
I agree with
why
that.
not,
Because you
No, I
also
also-
filed documents till the last minute.
no, this was not,
Night before the matter was listed last time,
my
you were
lord,
still
I
filing
plead
documents.
guilty and I will accept not what.
Let it verify.
Then may I just say,
List on next.
Lord, may I just say this, don't have it on the first of all. Have it-
First, not on
No,
first?
No, I'll just tell you first.
Fourth then.
Eighth, Lord, if possible.
Eighth, is it?
Eighth,
Very good. Eighth,
Lord.
8th September.
Eighth, Lord.
Deeply obliged.
Can I make a little suggestion subject to what my learned friend says? The file has become a little voluminous and it's, to be frank, it's a little all over the place. What we'll do is not, I'll give you a lot, we'll just make if my friend,
The compilation, not a.
we'll make a
convenience
compilation, Lord, and we'll give it to your lordship 3 days plan. I will ask my AR to sit with my friend, so it's a common compilation rather than your lordship having to do double work.
Common compilation will be filed by the learned council for the parties.
By the fourth.
said date.
Grateful.
Deeply obliged.
65.
Lord, I am for the complainant. Since I was not there before the High Court, I am on the application also seeking permission to file the SLP. So Lordship, may kindly turn to page 3, my lord. The only consideration.
There is gunshot residue on the hand of the deceased.
My lord, yes, I'll explain that. Lord, 3 bullet injuries.
And then you also file a suit. You file a suit and obtain stay order against the accused. In relation to the property, because you are.
Lord, that's a different aspect.
You will perhaps now be the LRA.
But I am, no, that hand residue I will explain, Lord. I will explain. 3 bullet injuries on the head, my lord. No, but both of them were in the same room. But the explanation would be that because there was scuffle.
Gunshot residue will come only if you shoot.
Lord, if
not because before the gunshot, if you just.
If
have
my
a scuffle.
hand, if my hand is on his hand, my lord, while he is.
After he shot you.
When he's shooting, my lord, that's what I'm submitting. Scuffle. My lord,
So while he is shooting you on the head,
who will, my lord, fire 3 shots, my lord, in self-defense? 3 shots, all 3 in head.
Lokesh, you're after the property.
No, not at all.
No doubt about it.
All 3 are.
You file a suit also and secure an order
Lord,
while he is in prison.
Lord,
Then
all 3 in head, my lord. Lordship would consider this aspect, my lord.
you're attacking the mother, saying that she is also responsible, and then the son goes.
There is a. Lord,
you get the
gun has been recovered from him only.
Sorry.
The mother has given the disclosure statement explaining how he did it. Lord,
Not a case for interference.
But only 8 witnesses out of 38.
Find no ground, no good ground and reason to interfere with the impugned judgment. Respectfully, petition is dismissed.
66.1.
They need to stay the award, not the judgment. 66 is not coming up today. 66.1 alone.
Yes, Your Lordship. For staying the award, not the judge.
The order dated 8/8/2025 shall stand modified and corrected to the extent of the second paragraph, which shall now read as follows. There shall be stay of operation of the award dated 22/7/2024 till the next date of hearing. IA number 195028 of 2025.
Alright, Your Lordship, there was one more aspect which Your Lordship may consider. There is one civil appeal number 3705 of 24, NBCC India Limited versus State of West Bengal. My case also gets covered in that, whether on the date of registration of MSME certificate, whether the services can be given prior or after. So my request.
No, but we've already tagged it with this civil appeal.
Okay.
Tamil Nadu Cement. Let it remain with
Obliged,
us.
my lord. Obliged, my lord.
Yes.
Obliged.
67.
Item 67 lots, 67 lots, I got on to, in order my lots may pass.
No, but has this person been appointed? Because some contempt was filed. You've come with 320 days delay in filing. No, leave that. But because of the contempt, have you appointed?
No, my lords, the matter is coming up on 5th September.
Before the High Court.
Before the High Court. My lords, in fact, the only issue really is that I bow down that while he's a minor, we should condone that delay. I am not taking
He
issue with
became a
that.
major in 2006.
Yes, it was that 4 years that he waited because in 2006 he would have.
Wanted to finish his graduation perhaps and get a better job.
Yes, my lord, that is what the issue, but then that is one of the reasons why it has been rejected. So the 15 years delay is not there.
15 years.
It's not 15 years, my lord, but there is at least that 4 years.
No, but according to your rules,
it's
the
5 years.
compassionate appointment should
5
be
years
within
from
5
then.
years.
But there is.
But she was not in a position, the widow was not in a position to.
My lords, I'm also not quibbling with that. Receive pension, they have agricultural.
Special pension or something you gave her.
Yes, my lords, 1.18 lakhs per year. They have agricultural land. Admittedly, she had 4 minor children when he died. But the petitioner himself.
Issue notice on the condoned delay petition as well as the special leave petition. Returnable on 10th November. Service shall be effected by all modes including justice.
Contempt petition may not be given effect. Unless we can.
We'll have to stay the order. I do not believe in staying contempt proceedings.
Stay the order. That's what.
The impugned order shall remain stayed till the next date of hearing. Operation of the impugned order shall remain stayed till the next date.
I'm very good.
One thing will make clear, operation of the impugned order, if not already implemented, shall remain stayed.
Not been implemented.
Because we don't know what happened before the contempt vote, unless you've been given proper instructions.
Have proper instructions, my lords, the
But
matter
it's
staff
not,
is-
it's
it
not
has-
been
It
implemented.
has not been.
Correct.
And-
Yes.
Well, there may have been a problem of justice here because my counsel was not here. But I tell you,
We have time and again said miscellaneous applications in disposed of matters.
that is true.
Not proper.
In the
You can't ask for an open court hearing by way of a miscellaneous
Well,
application because the review will not be
no,
taken up in open.
Well, I appreciate the discipline. Give me 2 minutes. Suppose I make a misstatement to your lordship directly, which I'm on the record.
Even then, it is a
And I
matter
get an
for
order from your
review.
lordship when my senior counsel is not here.
Even then, it is a matter for review, not a matter
Well,
for
this is a
recall.
very grave miscarriage. Just
It is
consider-
not a matter for recall. The registrar is
Very well.
completely
May-
justified in
may I
saying
give one
that
sentence? Well,
this is an abuse.
Well, can I just give one sentence? May I just take literally 1 minute? Your lordship's entire order of that day, 17th April, is based on production of original documents. Well, if your
Whether
lordship
the
was told,
state came to the aid of the complainant
the
and produced
complainant
the record, the
doesn't-
IO gives the documents to him.
I'll tell you
We don't
lordship
know.
exactly I
We don't know
visited.
what happened.
Well, no, Mr. Siddharth Agarwal could not appear. Your lordships were not told by the complainant that the police has come and given you this, and the police supervisory and seizure memo is with me. I gave the documents to the police as a written document.
Not a case for an MA, please.
Whether the
Fine.
inquiry is going on against the police for this kind
Then
of, then a lordship will
this
say,
application
well, then
according-
I will go in my review. I'll immediately file a
You
review.
want to withdraw the application.
Withdraw with liberty. Because what
Then
happens?
senior counsel
Not
for the
told this.
applicant, having argued for some time, seeks permission to withdraw the miscellaneous application filed against the registrar's order dated.
I with liberty to.
29/5/2025.
See, with
Reserving
regard to that
liberty to
fraudulent
the
document or
petitioner.
something, a document relating to fraud,
To the petitioner.
Now that the case,
production of original document before them.
Appropriate remedies available to him in accordance with.
now that the case is over,
Miscellaneous applications have been dismissed as withdrawn with the liberty.
now that the case is over, Melissa, there are 10 pages here which show that the other side's case is that I have the documents. Their case. Unfortunately, that day, whether we not able to put it across, the complainant should have told your lordship. That was the problem. Anyway.
Yes.
Item 69.
May please proceed.
69 perhaps is covered by the earlier order.
Yes, but
We take Paria.
They are
Not, we've already checked picked up Arunima Paul. Arunima Paul is differently situated. Arunima Paul is
In
not.
this matter, they have been allowed admission.
They are admitted already.
They are.
Applications have been filed by them. When they file the, they have to, they file the, they'll admit, they'll be, sit for the
They
examination.
will be sitting for.
Yes, they're not an issue. They want, Manoj, that the marks, the process of giving marks should be changed.
Your lordship.
Some process should be changed.
Vivek Paria order will apply.
Exactly.
Your lordship order 21st August.
That's Vivek Paria, then they will not admit. They'll be allowed to admit, Manoj. 73 have been given admission card. The admit
Blood,
card.
in this lordship, the.
73 have been given admit card. Record my
That we direct that in the meanwhile, all selected, appointed, untainted candidates who are permitted to be continued service still also shall be allowed to participate in free selection process without insisting upon their. Yes.
All they have made the applications and they have been given the admit cards also.
That based on.
They have been given the admit cards.
Based on this order.
It is a policy
They are
decision, sir.
conducting written test on 7th September.
We don't know. We said that
They have seconded, they have given the admit card. That record, statement will be recorded.
the others that Vivek Paria case, the
Yes.
applications were yet to be
Yes,
submitted.
yes.
That is why we had to
They
extend.
have already submitted in terms of your lordship's order.
Necessary to extend the.
Not this
In terms
second
of
of.
your lordship's order, they have also submitted.
Lord, only 1 minute I will make this. Lord, in based on your lordship order, the notification issued by referring your lordship order on 21st August, written test is to be held on 7th September.
Very good.
Yes, Lord, 7th September is very short.
No, it's not decided.
Same order, maybe.
Can't get up, sir.
Much
You
of-
can't, you
Tag
can't.
along with the very same. Much of. it.
It's not entitled. Same. We'll
Great.
We'll continue.
Yes.
Already.
Much of. Great.
Issued notice
59?
and tagged it with that.
Well, 69, practically your lordships have decided it.
Very well, it
Since
doesn't
they
matter,
have-
we've already got Vivek Paria, so let it
No,
come up.
Vivek Paria, we have allowed him, and here they have also allowed. They are challenging the entire rules.
Council has also gone.
They are.
Let it just come up with that, what difference does it make?
No,
You
sure.
don't need to
All
find.
right, all right, all right. All right.
70,
Lot 70
yes.
is on merits not fully covered by judgment delivered by your lordships. That a remand can be there in exceptional.
I'm appearing for the caveat.
Remand can be done under exceptional circumstances. Please see the paragraph.
Just before my learned friend starts, my lord,
No, but it's a nil award.
Yeah.
my lord, I
It is
am,
a question of remanding it
I'm
to
only
the city
requesting,
court.
I'm only requesting, my lord, your lordship may consider having it on Monday or Friday, my lord, yesterday night, 8 PM, my lord.
Issue notice and stay because it's kept on 28th.
Your lordship may consider like this
This is
request.
not a case where the 34 court can now pass an
My lord,
award.
yeah, there are, my lord, the 34 court has passed a completely unreasoned
No,
judgment.
no.
Whatever it is, what is the point of, it's a nil award. At least if partially some relief was given
60-page
to
order.
the award.
No, no, my lord, your
It's
lord-
one thing.
60-page order.
What is a nil award? What is the 34
does
court
not
going to
deal
do?
with, my lord, any of the objections that I have raised.
No, no.
Your lordship may consider, my lord, just having it, my lord, next
Issue
Friday.
notice will grant stay of this. You file your
My lord, may
reply.
I,
Stay.
my lord, may I, my
You're
lord,
not even on caveat council.
no, my lord, I am on caveat, my
You're
lord.
not on
Caveat
caveat,
is
there's
not
no caveat
registered.
rate.
I'm sorry, my lord, I have filed it on Saturday, my lord, yesterday night, 8 PM, I'll be served. Your lordship may just consider, my lord, having it on Monday or Friday, my lord, any date suitable. In fact, my lord, the judgment which my learned friend is relying upon, also, my lord,
17 November. So it shall be affected by all modes, including this thing. Mr. You filed a caveat, I think there's no mention of.
Saturday I filed, it's not yet registered. I have filed it, my lord. I have the
We won't
caveat,
say
my lord,
anything now, we can't validate your
My
caveat.
lord, in any case, my lord, there is no urgency that,
Then the operation of the impugned order shall remain stayed.
Obliged, grateful to you. Grateful. Obliged.
my lord, it's a summary judgment that has been passed in 34. Your lord, your lordship
We
is a
have stayed it, council, file your reply.
Well, it's an item 71 where actually moved the judgment letter, it's not been accepted by the registry. The mediation proceedings are ongoing before.
Very good. We've already directed our relation. For the petition, takes an adjournment on the ground that in the connected matter, mediation proceedings have been initiated. Based on.
Good.
When is the other matter coming up?
No date has been assigned, yes, please.
We'll just give the number, otherwise we'll say flag it along.
We'll get, that's a copy of this.
72, all the poetry persons have been granted bail.
No, what is your role? You are Convener Singh.
Yes, I am Kavinder Singh.
You shot Balbir Singh.
No, my lord.
And also
It's a
Charanjit Singh.
false
All others who used only
You are the
Lathi.
main guy.
No, my lord, the person who instigated, my lord, is equally guilty, my lord, he has been granted bail, my lord. The person who instigated, the persons who instigated, my lord,
He is the
instigated, my lord, they have been granted bail, my lord, they're really getting.
They instigated doesn't mean that you get instigated. Really, because your grandmother says do something, even if it's bad, you do.
It's a false complaint.
If you tell your grandmother this is
Very
not your
long
fault.
standing dispute within the party.
You can't ask me to kill my uncle.
He is your
You
father's
can't-
brother.
You can't ask me to kill my uncle, kill my first cousin,
My lord, at
shoot
best-
my other first cousin in the hand.
My lord, at best, it is case of culpable homicide, not already 4 years plus, my lord, at the jail.
The eyewitness evidence.
But he's not eyewitness, my lord, that I'll show from the record.
There's eyewitness evidence available. Merely because they're related doesn't mean
Their
that
evidence
this
has
is to
not been
be
recorded, my lord. There are 36 witnesses, 22 have been recorded.
You are the main culprit. So.
My lord, will grant me, my lord, time to, my lord, after 6 months, my lord, I will take my chance after 6 months, my lord.
Accordingly dismissed.
After 6 months, my lord, may allow me to work.
Not at this.
Lord, I appeal for the petitioner. Lord, in fairness, I must tell your lordship.
Notice orders, Mr. Nadkarni, we are not.
No, I'll
And that orders of 9th April 25. which
That
gave
leave is
you
pending.
1 week to surrender. You're 48 years old. You immediately develop heart conditions.
No.
Get hospitalized.
No, I'm not on that. I'm the only one out of those other, not several accused. I'm the only one who appeared. I'm the only one who appeared on
Not
VC.
surrender.
I appeared on VC.
You get hospitalized. You file an application for exemption from personal appearance.
I appeared on VC. Lord, I appeared on VC. Lord, may I just say this?
Any of the High Court is seized of the matter. We are not.
Therefore, my only request to your lordship is direct the High Court to decide on Thursday.
We are not going to
Lord.
manage the board of the High Court.
Lord, because my review is coming up, Lord, I tell your lordship what? May I just say one thing, Lord? Lord, the judgment proceeded on the basis that there is NBW and warrants against me and proclamation.
Whatever it is, it required you to surrender within 1 week.
No, I
You
surrendered.
did not do it.
Lord, I did. I appeared on VC. I'm the only one who
surrender. VC is equal to surrender.
Lord, I appeared.
Anticipatory bail is cancelled and you are directed to surrender.
Correct.
That doesn't mean you appear from Dubai
The date was given. Lord,
and say that I have
it was
surrendered.
not so, but
Visually,
just one request.
therefore,
One request may I make to your lordship?
not
Only one request. No, only one request.
yes.
Lord, High Court in both my matters entertained issue notice. I'm not asking for protection and all. I'm saying your lordship may direct the High Court to decide.
We've already said you, we do not manage the board of the High Courts, please.
We will make a request.
Lord, we will make a request. Let the High Court
We
consider.
won't say anything. You make the request.
No, I'll withdraw it. I'll withdraw it.
Then senior counsel preparing for the petitioner, having argued for some time, seeks permission to withdraw this special group petition. Permission granted.
To press before the High Court.
Accordingly dismissed.
Lord, to press before the.
Nothing. No windows also.
No, I'm there before High Court.
Neither doors nor windows will be open. Sorry, Mr. Nadkarni.
Not even through a little hole. No.
Not even a foothold,
Also.
not even a foothold will be allowed you to obtain here.
Like,
74, Lordship, they have filed on additional document.
Counter affidavit they filed saying
They
that
have
possession
filed, I
was
have to
not
seek
given.
instruction because some of the documents were never on record actually.
My lord, last time also they took adjournment on.
But I never sought it.
When?
My lord, my only.
They cancelled the last occasion.
My lord, we have.
You filed a counter recently only.
No, my lord, I am for the petitioner. They filed the.
They have filed a rejoinder, then filed an
With the
additional document.
rejoinder, they filed additional document.
My lord, my humble submission is, my lord.
But if you filed it along with your rejoinder, he is entitled to get instruction.
No, my lord, I am not opposing it, my lord. My only humble request is, I have been in possession since 1974.
They say possession was not even delivered to you.
That's not, that is the documents I have filed, my lord, to show.
No,
My lord, that document is at page 42 in the
demarcation.
My lord, page 42, original SLP, the possession letter has been filed. It's not an additional document. The additional document is that.
Where is the document which shows possession was
Page
delivered
142, my lord.
along with your application for additional documents?
No, my lord,
Then
with the SLP, annexed to P1.
page 41.
41 is the allotment letter, my lord, of 1970.
Possession
Page 43.
should be given.
Yes, and demarcation in field and on obtaining.
Where is it?
That-
After the demarcation, where is the possession delivered?
My lord, demarcation, that is what, the demarcation is.
There
additional
needs to be
document.
some record of delivery of possession.
That is the additional document.
Where is the record of the demarcation being undertaken?
My lord, that is the additional document. It's a separate volume.
Yes. Which page of the
Permission
addition?
to file additional documents.
Where is the demarcation?
My lord, annexure, if your lordship would kindly see, my lord, page 4, annexure A1.
Page 2.
4,
4.
annexure A1.
Yes.
This is a letter of 1980.
8 is refixed on.
August
for joint.
1980. This was done in 1980.
This was only asking for a
Yes, my lord.
staff to be deputed for the demarcation.
My lord, then.
Where is the evidence of the demarcation?
Page 8 now, my lord.
Yes. Further deputate for completion.
Completion of a field survey.
Where is the demarcation? We keep asking the same thing, you're showing us something else.
My lord,
Where is the actual demarcation report then?
my lord, there is a map at page 5. This shows the demarcation line, and of course we have filed pillars of demarcation also photographed.
That anybody can just put a pillar and stone and say there, this is
No,
the.
but page 5, my lord, this is the demarcation.
What is the date of this document?
No, but the date is not clear.
You can't even see the date. Where is the original?
My lord, we were given copy of the demarcation, the original they have to produce that.
This document seems to be sometime in 2008. Look at the bottom. 20th April 08, is it? Looks like 08.
I agree, my lord, it is not.
Looks like 08.
But my lord, they.
But this does not even say it's a demarcation report.
My lord, I'm submitting, my lord, that these was all demarcated, my lord.
Anyhow, let him verify them. When council appearing for the
My lord,
state,
there's only one thing.
take some time to
My lord.
verify the documents filed along with the rejoinder. Based on,
My lord, may I make only one humble submission, my lord?
yes,
When they respond to this,
22nd September.
let them make it clear, my lord, whether it is, they should not just answer to this, but also file the record, my lord, which shows demarcation, my lord, because now in RTI they have
The
answered.
council for the state shall also file an affidavit indicating in clear terms as to whether or not a demarcation was undertaken pursuant to the correspondence.
As of now, our instructions are that it was
1980. Correspondence in August 1980. Say it in clear terms.
My lord, we have filed these action documents in May 25. My lord, my only humble request is they are trying to evict us after 50 years after we have been in possession.
Don't do anything while the matter is pending. Status quo obtaining as on date with regard to possession shall be maintained till the next date of hearing.
Otherwise, they are actually giving false.
If you state that they are not in possession, they are not in
They are
possession.
not in
So if you are in possession, status quo will lend you until you are in.
obligation.
75.
That's the case, that these states on the same year, same transactions, they have said it's a composite, 70-30 will apply. 6(2)(b of the GST Act may be seen, the lordships have.
Where have you raised this ground in the writ petition?
This, your lordship kindly see page number 385, 386. 385, 386 for a minute,
Yes.
R. Somewhere in the middle, para R 385. However, kind attention is invited to para 41 of the influent order, where there is a reference to issue of classification on the subject activity having been decided in the states of Andhra Pradesh and Rajasthan. The Andhra High Court plus Karnataka, Maharashtra, Rajasthan. 4 states say same transaction, same year, composite. And now your lordship's judgment of 14th August 2025 says 6(2)(b), 226 is the remedy. Your lordship, kindly see the judgment. Unfortunately, the judgment could not be cited there because the influent order was 28/7/2025. Now your lordship says, my lords, if the state and the center authorities do simultaneous
Which para?
H, that para 96, 97, 97H is the relevant paragraph so far as 226 is concerned, but I can place 96 onwards plus conclusion. 96, 97H. Straight away says because the writ is the only remedy. After analyzing 6 to B.
But issue notice, returnable on 27, 13th October. So it shall be affected by almost including this.
But 17/125 assessment law order will have to be stayed. Because I have already paid up according to the other rates in the other states for the same period. The assessment
You are paid at the rate of 5%.
5% already.
5% you've already. They are asking for 18%.
18% plus.
The order dated 17/1/2025 passed by the Joint Commissioner, CGS.
Right.
Shall remain stayed
Great.
till the next date of.
Great.
I'm sorry, my lord, I could not be here on the first.
Yes.
Lord, your lordship's last question was.
What did you ask the CFS
Yes,
to
yes.
do?
Lord, I'm sorry, I don't have the copy.
Very good.
Your lordship may kindly have this. To be fair to the court, my lord, the CFSL says that further examination we can't conduct here. You have to go to some other laboratory.
Genuine or not, doctored or not. I think you ask them to match the voices also. But this CFSL is not in a position to do that.
No, that's what they
They've
say.
only spoken about genuineness.
Yes.
That's
But now the only laboratory which can do is the National Forensic Science Laboratory at Gandhinagar.
At
That is the
Gandhinagar.
best in the country. The only, my lord just.
Very well. We'll send it to.
Actually, my lord, if your lordship just looks at the credentials of Truth Labs, who has examined.
It is better that we have a second opinion, Mr.
Very well, your lordship may give
Now
them a
this is
short
the
time to.
National Forensic Science Laboratory.
Your lordship.
Laboratory at Gandhinagar.
At Gandhinagar in Ahmedabad.
No,
Gandhinagar is a second.
Gandhinagar
I
is.
was just pointing out, my lord, what the Truth Labs did was they compared.
Let's not go into that.
I just.
Let the report come thereafter.
Let the report come so that we can have a comparison. You will also have that benefit.
The questionnaire put to the Forensic Science Laboratory at Guwahati. This was at Guwahati.
Yes, yes.
Is placed before us, which indicates that the issue of matching.
There would be a
voices
CBI lab also. There is a CFSL lab and
in the
CBI also.
Admitted exhibit and the.
In fact, that may be more appropriate to send it to the CFSL.
CBI sends it to the NFSL.
Even Kasab's narco test, he was sent for Gujarat. It's the best.
And if it's the best.
Delhi's narco test was conducted.
What I'm saying is that if the CBI.
But he cannot choose the. I'm not choosing the best.
I'm not choosing.
Where do you want it to go?
No. If there is I believe there is a CBI CFSL lab here in Delhi.
You're right.
That
Now,
was-
what has happened, Mr. Kiran? Because of many such cases being filed before the CBI or CBI handling. So now they have virtually outsourced all their FSL to this NFSL.
I have no idea about that.
This I saw it in the website. In the light of the.
This is, my lord Justice Sanjeev Kumar, possibly the only forensic science university in the country.
In the admitted exhibit.
And the disputed exhibit. But no clear finding was returned by the said laboratory. We are of the opinion that the matter should be referred to the National Forensic Science Laboratory at Gandhinagar, State of Gujarat, to undertake the following exercise. The audio clip in question may be examined to determine as to whether there is any possible. To determine whether it has been edited, tampered, spliced, or modified in any manner. Further, the laboratory shall also determine as to whether the voice in the disputed audio clip matches the voice in the admitted audio clip of the person in question. And to give a clear finding as to whether it is the same person who is speaking in both the audio clips. Anything further?
Lordship may give them some whatever 3-4.
No, we will
audio
send
clip
the
in
very
question.
same questionnaire.
The audio
to the-
question along with the questionnaire shall be forwarded by the authorities to the
If your
National
Lordship-
Forensic Science Laboratory at Gandhinagar State.
If your Lordship just
Within 1 week.
At least let the court.
Report of, we would request the NFSL Gandhinagar to expedite the process and submit a report directly to this court in sealed cover within 6 weeks.
Please.
Based on
this truth labs had mentioned what is it that they are examining.
No, it'll be over. Based on 3rd November. 3rd November.
Oblate.
3rd November.
3rd November.
So I was just saying that the truth labs had mentioned.
We don't want to start
What is it that they were examining?
private laboratory is being.
Let us have this report.
Let's not go into it. Let's not go into it.
At this stage, it may not be necessary, Mr. Bhushan. After that, we'll hear you on, in case the report is not to your liking, you can also tell us about truth labs.
All right.
There I would have some reservation. It should be your lordship's satisfaction. If nothing would be of
As
his liking.
established by Justice Venkatachalaya, again and again, my lord, it's being objected to. Their opinion is sought by several high courts in the country.
Inaugurated,
By several.
because I was in Hyderabad at that point of time. There was a dinner hosted and I met Justice Venkatachalaya for the first time there.
Yes.
So I do know about it, but I think he inaugurated it. Not that he's a founder or something like that.
He was on their.
If I remember correctly, somebody called Mr. Gandhi is associated.
Yes. He is the main person. He
Mr.
was the
Gandhi.
director of the CFSL lab.
If you want us to repose faith in the lab because of the name, it's a different thing.
I'm not saying
But-
because of the name,
Why
I'm
go
saying
to-
because of the credentials and experience of the people who have done this examination. These are people who have 25 years experience in CFSL work. They have
Justice
worked in the
Venkatachalaya's
CFSL lab.
association with the lab, that extent, yes, he was there at the inauguration, but whether you can treat him as
I
a
think he
founder
was-
member or something like that,
Let's not go into it. No,
He was
otherwise-
on their board for a long time. He was on
he
their.
was on the board also. Very
Grateful to your lord.
I just mentioned that because
I am obliged.
even CFSL labs sent their difficult cases to this truth labs. So many examples of CFSL labs sending their difficult.
Place all that also on record if you need to.
I am
Post
aware
the
of it.
reputation of.
Let's not leave it as that. Obliged.
Item 34.
34. Yes, Ms. Nagpur. Would the issue not be covered by that Bharatam Ambale?
There are two judgments, both of coordinate benches.
Kashish.
Ah,
Kashish or
is one-
Kafish or something.
Kashi is one judgment. Kashi is one judgment. But there is another.
Bharat Ambale. Justice Pardiwala's judgment is also there. It's in my book. Bharat Ambale. Judgment. Would it not be covered by this?
Conflicting judgments, Muraz. Conflicting.
Which one? Which one conflicts with?
Can you see this Yusuf Muraz?
Yusuf. What does this judgment say?
Yes, you have to kindly come to paragraph 16.
23. Para 16.
Para 15, Muraz, Mohanlal.
Mohanlal is-
Yes, Muraz. Para 16, in the absence of any material and record to establish that the sample was seized contrary.
No, but this judgment is later in point.
Then Muraz, next line. It is apparent that the said seized contraband sample.
Don't consider. Earlier one. 23 and Justice Bela Trivedi's judgment.
That I am pretty sure. The judgment is completely in
No,
contrary.
where is Justice Bela Trivedi's judgment? Not a copy of it?
24, 11, 372, we already.
And then you have Justice Pardiwala's judgment. also.
Yes. Well, there are two lines of judgments. One line of judgment saying.
But this judgment just followed Mohanlal, whereas Mohanlal has been distinguished in Bharat Ambale.
Mohanlal was considered in this case by Honorable Justice Mitchell. He says it is mandatory on the violation, vitiate the conviction. Your Lordship, kindly come to.
No, but the later judgment considers Mohanlal, whereas Mohanlal is blindly applied in this.
No, here also Mohanlal is considered.
Considered and applied, whereas Mohanlal is distinguished in Bharat Ambale, as well as I think in Justice Bela Trivedi's.
What would be the case, Manoj, that there are 2 views now. For all of them, say, coordinate benches, you have to kindly see. Therefore, Manoj,
We'll have to perhaps examine, the other judgment I've not looked at. This is Bela Trivedi's judgment. Bharat Ambale I have, but Justice Bela Trivedi's I heard about, I'm not.
Manoj, there, Manoj, in paragraph 50.4, Honorable Justice Bela Trivedi, she says, Manoj, it would not vitiate the trial. Whereas, Manoj, Honorable Justice Mittal judgment says it vitiates the trial.
That is by following Mohanlal's case.
Yes, both Manoj, following Mohanlal.
No, Mohanlal thereafter was distinguished by Justice Patiwala in Bharat Ambale. It's not as if this judgment proceeds in ignorance of Mohanlal.
That is also by two judges.
No, but if the later judgment distinguishes it.
Say, Manoj, common law is the original judgment.
When it is coordinate benches, the later judgment prevails.
When the view is completely contradictory. Manoj.
There is a question.
But you have to kindly see the judgment of Honorable Justice Mittal. He said,
blindly applies Mohanlal. It does not examine Mohanlal to see whether anything can be carved out.
Mohanlal has been understood by the bench. Mohanlal has been followed by the bench. Mohanlal, according to this bench, Mohanlal.
Have you examined Bharat Ambale? Have you examined Bharat Ambale? Please go through it.
One more point.
Let us have clarity on the issue before we just blunder forward.
That is why I submit that the matter be
Not for the mere asking. We need to be convinced that the matter requires such a reference. Go through Ambale also and tell us whether Bharat Ambale needs.
Yes, one more thing is, one more issue. One more issue which you will also may have to decide is.
He doesn't say anyway.
So one more
Ambale and then.
I will do that. One more thing before that, you will not also kindly
Make a compilation.
One more point also you will also need to consider this. But here, 15 packets were seized. Sample was taken only from 2. But this report Morgan said, what's in
Each sampling has to be done.
what? Yes.
Each
Sampling
packet
of
something.
each packet.
Okay, that is confident concern with the this is governed by Union of India versus Bard Report. 2009 12 SEC paid 161.
Certain legal position after going through all the relevant judgments. shall examine, you say, don't say assessment, examine the legal position after going through all the relevant judgments and address this.
And this issue may also be cancelled.
That also you can.
Second issue. But I am also going to.
8 September.
That order, you also was a party to that order.
8 September.
In order, you also was a party.
52A.
Yes, 52A. The paragraph 1, Narcotics Control Bureau.
This Kashif is Justice Bela Trivedi.
Bharat Tambale.
That is Justice Pardiwala.
The ratio in the said action is binding. This also again to the bench. This order court had no occasion to approve. Now,
So now, as per this order, the courts are expected to follow these two judgments.
yeah, but this honorable court had no occasion to consider the judgment of Honorable Justice Mittal.
Justice Mittal only accepted Mohanlal and applied it.
There you go, that
There's
is also
no-
law, but
there's
today,
nothing more on it.
that is also law to the, uniform that I will file complaint.
Yes.
35.
Wait, please, Violence.
Yes.
Well, in this case, a interstate dispute between partners in a dissolution suit, where I have admittedly a 900-year lease, there is no doubt I am an owner, full owner, is used by the municipal corporation to take away my ownership. How it can happen, Malas?
It's a lease after all, so they terminate the lease, they're instrumental.
900-year lease.
And you've already filed a writ petition
No,
challenging the termination.
Therefore, no, I'll prosecute that writ. My problem is so long as it is uninfluenced by the observation, this interim order, this rejection letter, I understand what I'm allowed to say. This rejection letter, which is the subject matter of the present letter, today's letter, is 8.
Which observation in this judgment are you talking about?
All the observations are given against me,
Where is that?
Yes, yes. I understand that I have to challenge that. I already challenged it. I need that. This is not going to be binding. The findings are starting from para 12. Finding number 1. Because this should not bind the termination. Termination will be upheld on these findings. Para 12.
Yes.
Lessees have failed to comply with the order of 7/7/22. And
Where are you reading? Para 12?
Page 7.
Page
Page
7.
7. Order.
Yes. Where are you? Please have. Partnership is dissolved.
Yes. No, not the. There is
Are we looking at the same order though?
Yes.
It's page 7.
No, that's yes. Impugn order is 9 June 25. It deals with 7/7. It was dealing with our application.
9 June 25.
Yes. Now, para 12 of the 9 June.
Para 12. Where exactly are you reading? You?
Now, please, your lordship will go down. Sorry. Para 12, I've heard all learned counsel.
It's a very long paragraph, so you need to tell us where exactly you're starting from. You want to read the whole paragraph?
No. At page 8,
Yes.
5th line.
Yes.
It shows that the order of this court has not been complied with. It shows that the order of this court has not been complied with by the lessee's partners.
What is that?
Accordingly, on 8/11 MCGM. Now that is mistaken. The order said, 7th July order said.
That is with regard to your proposals for redevelopment.
No, they said that you give your consent that you are ready to give proposal, not give an actual proposal. The order has been misread. The order of the High Court said
There is a rejection of your proposal. That must be perhaps the subject matter of your writ petition too.
No, that is this one. That's what I mean.
It can't be the subject matter of an IA in a suit for dissolution.
That is right. Right. There is a mistake.
Really, because the suit
Well,
was
I
delayed,
am
doesn't mean that it should not
I
come
bow
out
down.
of the tracks.
A solution has to be found now. In a dispute of partnership, give me 2 minutes for this. In a dispute of partnership, we won. We are 87%. Now, against that, one partner filed an appeal. While the appeal was pending, BMC, at the instance of one builder called Avigna North Star, that's the whole problem. Clearly, he's controlling the whole thing. Issued us saying that this is a dilapidated building. We filed a proposal for redevelopment. The redevelopment was rejected on 8/11/24. That's the impugned order here.
Yeah.
That was challenged first by me, by an IA in the pending FAO of that suit. That was a mistake. In the IA, the present impugned order is passed. In the IA, in a dissolution appeal, that order is passed. The order says that my proposal for redevelopment by 87% is inter alia rejected because you, Mr. Singhvi, don't have 100% consent. How is it possible to have 100% consent when there's a partnership dispute going on? Clearly, it is one of very silly objections at the instance of the builder to find an excuse to reject my redevelopment proposal. Now, ironically, the redevelopment proposal is rejected on 8/11/24, which is the subject matter of my challenge in the IA and then losing in the impugned order and then coming here. On the same day, 8/11/24, at the instance of the builder, they issue a termination show cause. Ironically, the same day. That same day, 1 year later or 8 months later, they pass a termination order after I filed the present SLP. After I filed the present SLP. Now, today, if I go in my writ, every finding here will be used against me.
Which finding will be?
So number 1, 8. Number 1, 8. 8 verse, which I've read already.
There is no finding.
So it shows that I'm not ready. I've given a proposal.
As far as the termination of your lease is concerned, there's nothing. The judge says that you will submit your reply to the termination notice.
And after that, we have terminated and they have filed it. These are all recounting facts prior to this. I would have said nothing about it.
Interim order defeat my rights finally. Look at the total.
You submitted to the jurisdiction of the court.
Well,
They're filing a.
It's an interim
file
order,
there.
right? It's an interim order.
Very
It's
well.
a
So far as
subsequent
your
development by
is
them.
concerned, we will say that all issues are left-
Influenced by this observation.
all issues are left open to be considered in the written.
Well, that's one. That's one. That will take care of it. I don't think that's.
There are no observations here on the issue of the lease termination.
No, there is. Well, impliedly, it is that I am. Give me the page. Page 9. Page 9.
Page 9.
Just keep on saying. Come to Malas, middle of page 9.
Yes.
MCGM is challenging the right over the suit property on the ground that they have not obtained legal heir certificate to show that they are heirs. They are the grounds on which I am dismissed. Legal heir, 100%.
These issues will be left open.
The lordship said left open.
All issues are left open. All issues relating to the
One
termination.
point. Only one thing remains. In this interest, just give me 2 minutes. This is one part of the solution. I have no problem. In this building, which is an old building, where 100% 900 years, we are the owners. They have buried 20% whom the builder has captured. Now, what I am all saying is that in the meanwhile, there was a receiver collecting rents.
That was since 1974.
Continuous. That has been removed. By this impugned order, that is removed.
There's a termination of the lease. there is a-
Right, that's all right. If the matter is going on in the High Court, we will, fellows, if necessary, apply for renewal of that there in the High Court. But
Why should the Supreme
what
Court?
my Lord Justice Sanjay Kumar notes,
We can't open doors for you.
can I, your Lordship note something going on?
You've already invoked the 226 jurisdiction.
220 is another story. For 1 month is not listed in Bombay High Court. Your Lordship
That
knows
will
the
have to
reality of the
follow.
ground. But that's a different matter.
I never accepted it.
If my Lord Justice Sanjay Kumar notes that there is a receiver from 74, the balance of convenience requires the receiver continue for 2 weeks more. How come?
Not after. Please, you want us.
There is no tenant, there is no building, it's a piece of land there. What are you
The
saying?
inspection is pending there. We can't put the cart.
That building has been demolished, there's nobody there.
Give me a liberty to apply for
They
this.
wanting to come.
Give me a liberty to apply for this also to the report. Give me a liberty to apply for this also to the report.
Nothing at all.
I will apply for this also.
Not at all, no
By
liberty.
the High Court. We are also informed that the Municipal Corporation of Greater Mumbai has terminated the lease after the institution of the special petition.
Yes.
And the same has been subjected to challenge before the Bombay High Court by way of a writ petition. All issues are left open to be considered by the High Court in the said writ petition.
Yes.
Liberty to apply for receiver. I don't ask.
I am sorry, that it should never be.
I will apply.
I already said we're not going to open doors or windows also. Or windows also.
Your Lord,
You are.
You don't need courts liberty to make an application.
We can't direct as to what interim relief should be considered by the High Court.
Your Lordship, in item,
Make a prayer.
in item 27, Your Lordship, some.
The real story behind it
Some
is the builder.
error, 27, Your Lordship.
Property.
Some error has been crafted, Your Lordship, in the order.
27.
27, that daughter's POSCO, Your Lordship. One more, Your Lordship, this matter pertained to 2009 and the amendment came in 2019, Your Lordship.
So that time, the simple imprisonment was.
2018 conviction.
Conviction is 18, beloved,
18.
but the incident 2009.
That doesn't mean that the conviction is under 6 POCSO.
Beloved, that's all right.
Where is the question? Once it is under 6 POCSO, the sentence will follow.
Beloved, the session court has given the sentence of life imprisonment.
Life imprisonment under 6 POCSO.
Yes, Your Lordship.
6 POCSO says minimum
Remainder of
sentence is 20 years or life imprisonment till the end of the natural life.
But Your Lordship, this came in 2019.
Once the conviction was under 6, then it's
This amendment was 2019.
Which amendment?
This amendment that life will be treated as.
Sorry, you continued to rape the child, both of them.
It's all right. I have
Your own daughter, your first rape was in 2009. Thereafter, you continued in April 2010 and also and the other daughter, you raped her on 18/3/2013.
13.
Which is after POCSO came into being.
Milord, the POCSO came, but the 2019 says only that life will be.
You can't say that I am to be indicted only on my first offense. When you continued with the offense, you continued to rape your daughters.
FIR is
Where is the question?
2013, Your Lordship.
FIR is of 2013.
And-
Therefore, it is after POCSO.
Milord, the till natural death come in 2019 only.
Which one? POCSO amendment?
Yes, Your Lordship. 2019 only, 16/8/2019.
Section 6.
Earlier it was simple imprisonment, life imprisonment.
Very good. Then the 20 years you remove till the end of the. This came in 2019.
2019, 16/8/2019.
No, but it's substituted. It is not amended.
Yes, Your Lordship.
Substitution will mean it dates back.
Milord, in this case,
If the legislature in its wisdom said we are substituting it, substitution will mean it dates back. If it's amended, amendment might be prospective.
Milord, the offense of course is
Then
a
it
heinous
remains-
one, Milord.
Then it remains counsel.
Milord, High Court and there is no state appeal, Your Lordship, regarding this matter.
That doesn't mean that you get away easy. Let your daughters at least live their life peacefully, knowing that you won't come out of prison.
Milord,
To have this kind of father again lurking around them, it is not an easy thing. Poor girls will have to
Milord,
be
it's an
treated.
animal instinct, Milord.
Poor
The
girls
person
will have to
given a-
be
the
treated
person
for
should be given a chance of
trauma.
reform, Your Lordship.
Where is the
Otherwise,
question
reform
of?
goes.
This is
Protector-
beyond redemption.
The protector becomes the predator.
2 daughters, not even 1. You didn't leave the second daughter also.
Milord, the lab.
What
it is
kind
up
of
to Your Lordship.
animal is he?
It is up to Your Lordship, that's what is the, but the High Court and both the courts below
No,
has
sorry.
given the life imprisonment.
Milord, sir, may I mention?
You're
I'm
not
sorry.
going to change.
I'm sorry, Milord. May I mention item 40? Actually, there was an interim order previously by past my lords, Lord. I'm sorry I could not
Sorry?
point out that time.
There was an
Item
interim
40,
order.
Milord.
Exemption from service.
Yes, that's exactly.
needs
The interim order dated 2/9 shall continue to operate till the next day of hearing.
Very
That's
good.
today. That may be,
That is
I'm highly obliged, highly obliged.